Justice of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court will draw near to your attention and shall hear.
Thank you. Please be seated. Well, good morning. Before we begin today's calendar, we have 3 candidates for admission to the bar who will be sworn in this morning as attorneys and counselors at law. They are appearing here together with their families and friends who are here to celebrate this achievement with them. So to all of them here, welcome. I'm going to ask the candidates to stand briefly to be acknowledged when I call your name. Kendall H. Anderson. Welcome, Mr. Anderson. Naima Asa Hagler. Welcome. James Brian Williams. Welcome. Ann Dillon Flynn, the clerk of the court, will administer the oath. Ms. Dillon Flynn, have these candidates been certified to the court for admission by the appropriate committee on character and fitness as possessing the character and fitness required by an attorney and counselor at law?
Yes, Your Honor, they have.
Please administer the oath.
Please raise your right hand and repeat after me. I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of New York,
and the Constitution of the State of New York,
and that I will faithfully discharge the duties
and I will faithfully discharge the duties
of an attorney and counselor at law
of an attorney and counselor at law
according to the best of my ability.
according to the best of my ability.
Congratulations.
A career in the law is very often driven by the desire to be in a position to help people. People who are very often at desperate points in time in their lives. People who feel like there's nowhere else to turn. You as attorneys and counselors at law will be the person they turn to. It's an extraordinary gift to be able to help people in such a way, to play such an important role in the lives of our clients. I wish you all great success and am confident that the years ahead will be filled with great accomplishment and satisfaction. Congratulations. Thank you. And we'll now turn to our calendar. The first case on for today is case 361, People versus Richards.
Good morning, Your Honors. Nicholas Texedo for Appellant Franklin Richards. Your Honors, that issue here is an issue that, according to the record, apparently comes up in every case in Erie County, which is disclosure of the in-camera testimony that was the basis of the search warrant, which in this case, Your Honors, was really the meat of the warrant application. The application itself did not set forth sufficient facts that we can look at it and say, okay, this warrant was valid or this warrant was not valid. Counsel for the appellant moved in criminal special term and before the issuing court to attempt to get the information contained in this in-camera, offered to do so on a basis under a protective order where they could not disclose it to their clients, offered to have names redacted. The prosecution opposed and all courts denied relief. That left counsel in a position and left the appellant in a position of making a decision without all of the relevant facts before it. For instance, this was a two-family house, a two-family structure. Nothing in the warrant application would have allowed for a warrant to issue for the entire residence. It is unknown to us at this point whether anything in the in-camera proffer would have got them over that hump.
Counsel, let me ask a question. Is part of your argument in this case that the present for the in-camera interview was the detective and likely an assistant district attorney?
Certainly the detective, because the detective says it in his affidavit. There was
And you surmised that a DA would have been there also.
potentially.
Right.
I know sometimes DAs are, sometimes they're not.
Right.
In our view, it doesn't matter if it's just the detective or both, because the information possessed by the detective is imputed to the district attorney as well.
That's where I'm getting to the argument. So part of your argument, as I understand it, is the transcript of the proceeding may be sealed, but the information that those individuals, either the detective or both the detective and the DA have, because they were present, isn't sealed. That's part of your argument?
Correct, Your Honor. That is part of the argument.
So I don't know that I've encountered that argument. So you're drawing a distinction between what's transcribed and the court sealing the record and what's in the memory of the people that were present. Why wouldn't we assume that when the proceeding is sealed, that everything that took place in the chambers or wherever the judge was doing this is sealed? In other words, once those folks that are present understand that that proceeding is sealed, they are precluded from talking about what transpired there.
So I believe the language in the sealing order would only apply to the record of the in-camera testimony. I suppose if somebody didn't give a name, it wouldn't matter what the person said, and that's really what we were looking for.
But isn't that part of the problem, though? What the person said, and I think what the judge was getting to here was by revealing information, they could figure out who the person was. And isn't that always a risk in these proceedings? That it's not just the name of the person, but it's other information that could be part of that proceeding that's contained in the transcript or contained in the memory of the people that are present there that could reveal who the person is that is giving the testimony, correct?
Yes, but I believe there's a procedure that is there for that possibility, which is protective order. And in this case, the defense offered to have the information disclosed only to counsel without names. In that scenario, there was no risk that counsel would know based on who, or based on when the person was there, who the person was. And if counsel was prohibited from passing that along to the appellant wouldn't know either. There's a statute that would deal with it, which is the protective order statute. So really a big part of our point is that instead of simply sealing these at the outset, at the time of disclosure, the prosecution has at their disposal the ability to make an application for a protective order. And in that case, then counsel can be a meaningful participant and make the offers that were made in this case by the defense.
Did trial counsel request that proceeding and the transfer of that proceeding be reviewed by our court?
Did trial counsel request? No, because
once it was denied.
right. Well, it was so what we never got, or they never got to the stage where motions could be made. This ended up being an SCI plea because the plea offer was going to expire and counsel didn't have the information to counsel his client through that.
Didn't counsel make a motion though to find out what was contained in the transcript?
Two, in fact, Your Honor. So
and so once that was denied, and it was denied,
yes,
was there a request to have that denial reviewed by our court? The in-camera denial of the in-camera inspection.
That's what this appeal would be, Your Honor. We didn't, because it wasn't done under the protective order statute, we didn't have the interlocutory appeal available to us. The 24570 was never invoked in denying us this. The point is they did an end run around the protective order statute by simply having it sealed at the outset. The other issue would be diligence. If the court finds the prosecution did not have this information or material, they have an obligation to come into possession of it. What they did here is the exact opposite. They exercised due diligence to make sure they didn't come into possession of it.
So in your view, your appeal includes the appeal of the lower court's denial of the motion to unseal. That's part of your claim here.
Yes, we believe it does because these were all things that trial counsel attempted prior to taking the plea as a last resort.
And we would need to find an abuse of discretion on that.
Yes, and I believe what we would say is we made every offer to allay any concerns that any parties, the prosecution or courts had with the disclosure of this information. Again, just to counsel and no names. And it was clear that what the appellant wasn't doing was trying to find out who this person was so they could retaliate. It was clear that counsel simply wanted the information to make the best decisions on the case. There's a good chance that
The court expressed a concern, and we see this all the time in medical malpractice cases where you do these partial disclosures of experts. So this concern that you do a little bit of a disclosure, it's going to be found out. Why isn't that sufficient? Why isn't that enough of a basis?
I guess I just don't see how disclosing, I was at this residence on May 14th of 2022 to counsel only would risk anybody finding out anything about the informant and who it was. Obviously, it's a crime if counsel then discloses that information to his client. So getting the information to counsel simply so they could do their job, I don't think would run that risk at all. There are Supreme Court and New York Court of Appeals cases that would seem to indicate that as a due process right, the defense would have a right to know what was said in this in camera. And in this case, like I said, on the face of what we're looking at right now, this warrant is invalid. However, we don't know what was said in the in camera. And that's why the appellant couldn't afford to risk that and risk a higher sentence without knowing exactly what was said. Had counsel had the information, there's a good chance that counsel would have told Mr. Richards, no, do not take a plea, let them indict, and we're going to file motions. In this case, we had to go back to before 2020, where counsel had to have his client make that decision without all of the information that would have been available.
We'll take a look at that, counsel.
Thank you, Your Honor.
Thank you.
May it please the court, Jerry Marti for the people. Due diligence under the discovery statute is guided by reasonableness. So the question boils down to whether it's reasonable to expect and require the prosecution to file a motion to unseal court records, followed by another motion to protect a confidential informant and possibly endanger future criminal investigations. The answer is no. Discovery statute should not be expanded beyond the intent of the legislature and its plain language. CPL 24520 sub 1N deals with the discovery of transcripts. Nowhere in that statute provision is there anything about sealing and obligating the prosecution to look for sealed records. And that is because it can't. According to the introductory paragraph of CPL 24520 sub 1, it has to be in the custody, control, or possession of the people. And certainly the records that are sealed by the court, everybody could agree that the court is not under the control of the prosecution. Second,
Assuming that the court was the only one that had this transcript or had a recording, I don't even know if it was transcribed, but that doesn't really matter. But there was this motion to unseal it, and with these protections in place, the redaction, attorney's eyes only, et cetera, that kind of thing. Why wasn't it an abuse of discretion for the judge to deny that?
first, when in this particular instance, the search warrant was approved after a court review. So there's a presumption of validity. Second, there's a balancing test. So it depends on balancing the public interest in a free flow of information and avoiding a chilling effect on law enforcement investigations versus the defendant's interest. Here, the information, the court said it could be imperil the confidential informant. In other words, imagine if the prosecutor now in another case confronts the confidential informant and says, we're now going to disclose it to defense counsel and possibly endanger a future criminal investigation. The court took that into consideration in doing the balancing test. Now, this is much different. Now, defense counsel makes reference to other cases. This is much different than the Roviaro case that was cited. In Roviaro, the confidential informant worked with the defendant and then later on said, I don't know this guy. That's much different because now it implicates a strong interest for the defendant to have this information, which was not present in this case.
All right, but what you're suggesting here is let's assume that the attorney's eyes only provision is held. Let's assume the attorney doesn't tell his client, oh, this is what I learned about the confidential informant. Let's assume there's no breach. You're suggesting that if a confidential informant knows that some information about them may go not to the defendant, but to the defendant's attorney, the confidential informant will say, you know what, forget it. I'm not gonna testify at all. But that's going to imperil future because of perhaps the nervousness of the confidential informant, right or wrong. Is that part of the argument?
Yes, Your Honor. It could have a chilling effect on investigations. But I want to go back to the due diligence part because I think this is the whole crux of it. There's another portion of the CPL 24520 sub 2, which deals with the duties of a prosecutor. There, the legislature included language that the people do not have to file a subpoena duces tecum for materials if the defendant can get the same information. If that is the case, then the prosecution shouldn't be obligated to file two motions for information that the defense counsel can seek on their own. In fact, that's what they did in this case by filing a motion to unseal.
Counsel, let me ask you a question. I think part of the argument that your opponent's making is the information that took place there, at least in part, that is whatever's in the memory of the investigator or the DA, if there was a DA in the room, is not part of the transcript and hasn't been sealed. So that information, I think you'd agree, is within the control of the people. And so how do you distinguish between the transcript that's sealed and the information in the minds and the memory of the investigator and the DA if one was present?
I would direct the court's attention to CPL Article 245.55 sub 2, which deals with the flow of information. And in that provision, law enforcement cannot make that information available to the prosecution if there's a court order. Now, we don't know the parameters of the court order in this case. We do know that there's a sealing order because they filed two motions to try to unseal those records. So it depends on what's in the language of the court order. So it really boils down to that. Moving on to my last point, which is the effective assistance of counsel. And I'd like to bring up that point in the context of the discovery statute. Now, the whole point of the discovery statute is to avoid delay. You get the prosecution to provide information before any major event such as a plea hearing or trial. Fine. Now, on the flip side, which was brought out in this case, the defendant has a right to effective assistance of counsel in meeting meaningful representation. What that means is that defense counsel should file that motion to unseal if it's warranted, unless there's a legitimate reason for not doing so. And that legitimate reason can never be, I'm not going to do it. The prosecution should do it, and we should expand the discovery statute to allow for that. That is what was rejected by this court 3 weeks ago in People versus Pew. Defendant argued that they were entitled to more discovery prior to a predicate felony offender hearing. The court said, if it's not in the plain language of the statute, if it's not pursuant to the legislative intent, you're not going to get it, and it's just not part of discovery. The same thing applies in this case. And unless there's any other questions, I'll rest on my.
No other questions, counsel. Thank you.
Thank you.
Case 362, People versus Santana.
Good morning, Fabian Santacroce for John Santana. This is a roadmap. I plan on speaking about point 1A, point 2, point 5, 6, and 7. For point 1A, the evidence was legally insufficient to prove Mr. Santana had the required larceny intent as to the Jeep, and the verdict convicting him of that count was against the weight of the evidence. That was
Okay.
count 7.
So counsel, that wasn't preserved.
You're right, it's not preserved, but I'm asking that you get to it in the interest of justice, and if not, I do talk about it in my ineffective assistance of counsel claim.
And can we also, infer larcenous intent from the act itself?
I think you have to go a bit further. So the Court of Appeals in People versus Jennings talks about larcenous intent. And in essence, the required mens rea is to exert permanent or virtually permanent control of the Jeep or dispose of the Jeep in a manner as to render it unlikely that it would be recovered by the owner. And that's kind of definitions of deprive and appropriate under the penal law, which obviously is something I'll get to in point 2.
Sure.
But that language from People v. Jennings is adopted by this court in People v. Williams, 2007 case, as to robbery in the second degree pertaining to a vehicle. So while the taking element in this case may have been established, that doesn't require, that can be temporary. And I guess in essence, what I'm saying is the mens rea element of larceny that I think is required here is more than just temporary.
So you're saying because you abandoned the car.
Not just because he abandoned it, of course, because, if you abandoned it in another state or, 50 miles, 100 miles away, maybe I don't think my argument's as strong, but 10 blocks away, doesn't take the license plates off of it, doesn't take anything out of the vehicle. There was testimony that Mr. Reyes lived in this vehicle, and you can see from the photographs that there's a lot of property in there. None of that was missing. This thing was unscathed, 10 blocks away from the scene, 4 days from the incident, but one of the witnesses said it had been there for 2 to 3 days. So in essence, my argument is that I think the evidence shows that this was likely to be recovered. If this was a smaller item, like the other things that were taken, of course, you throw a ring or a piece of jewelry just on the side of the road 10 blocks away, the likelihood of it being recovered isn't great, but that's not the situation here with a motor vehicle, with the plates being left on, with everything just being unscathed. And obviously, this kind of goes into point 2, which is that I think that the definitions of deprive and appropriate should have been read here. If you look at the charge, the charge for the introductory charge for robbery, that's, footnote 2 in the introductory charge of robbery actually quotes People v. Blacknall, which I talk about in my brief. And I do think it kind of puts a duty on the court as well, even though, again, not preserved. Again, go to the ineffective assistance of counsel if you'd wish.
Can I ask a question about that?
Yeah.
In terms of, that really wasn't the defense. So when you read the transcripts, the defense wasn't, just took the Jeep temporarily to get away and tried to bring it back close to him, and left the key in it, all of that. The defense was that he didn't take it at all.
Well,
and so how do you do that as an attorney? Don't you have to make that choice? Isn't that a strategy call?
I was hoping you'd ask this. I think that, of course, he's going for it didn't happen at all, but he also asked for all the lesser includeds that he thought were appropriate. And he does say in his summation, the defense attorney says in his summation that he goes to these 2 things. It's found close by and it's unscathed. So I think he was hoping for an acquittal, but he also asked for all the lesser includes that he thought he could. And then he did touch on the Jeep being found 10 blocks away and being unscathed, which is getting to this. He just didn't quite get there for whatever reason. So as to point 2, if you look at the footnote for the introductory charge to the robbery instruction, it says that the following definition of larceny should be used unless the circumstances of the case suggest the need for or a party requests. And I'll stop there, but I do think it puts a duty on the court. And honestly, I don't understand why this introductory charge doesn't have the definitions. Petty larceny instruction has the definitions. I don't know why it doesn't, but that's obviously, that's my opinion. And I don't think this is harmless as to point 2. And that's based on my arguments in point 1, of course. As to point 5, this is about, making a minimal inquiry after a seemingly serious request. I do think on that first sentencing date, he does make a seemingly serious request. He talks about 3 specific things. One of them is the repugnant verdict. I don't think that we can push that aside. The other 2 are kind of about failing to investigate. We'll just put it at that. He's 20 years old. He doesn't ask for a new attorney at that point, but he's in essence saying, I want time to do a 330 or a 460-50. The court grants an adjournment. The defense attorney doesn't say, whoa. If he wants these things, I can't do it. Because in essence, he's calling me ineffective. But on the next court date, when the attorney comes back, doesn't even address those two things, just addresses the 30-30. That's when my client says, okay, I want a new attorney then, and reiterates one of the same complaints from the last court date. And then the judge says, denied, which is unfortunately kind of, I think you've had other cases with this judge on some similar things, and, so he just denies it and moves on. I think that was an abuse of discretion. I think there's an irreconcilable conflict at this point between them. And that kind of takes me, to the ineffective assistance of counsel.
Well, before you move
Sorry,
on.
yeah, of course.
I mean, in that last scenario, if we determine that there's not any merit to the 30-30, then of course, failure to make that motion wouldn't be ineffective.
Right, and so I don't know if there was merit to the 30-30. I think there perhaps could have merit to the 3-30. So because obviously it has to be in the record, but there is some things in the record that my client went to Monroe High School, not Marshall. So yeah, and so, point 6 is kind of a summation of everything, this failure to investigate, which perhaps is more appropriate for a 440. I do think there is enough in the record. And then talking about, points 1 and 2 again, we already talked about why I don't think it was strategic not to ask for the definitions. And obviously I noted some other things that I won't.
Also, I'd like you to get to harsh and excessive.
Yes, of course. And that was my next point. Barely 20 years old. Yes, he had prior contacts with the system. I can't deny that. 13 pins. I don't really think the pins should be held against him. I think, father leaving them and was kind of with the pins thing. 15. Yes, we have a prior robbery. If raised the age existed at that time, perhaps it would have been removed to family court. We'll never know. It was 2 counts of robbery, 1 incident. We don't know if it was two separate people or 2 counts of robbery, same person. Okay, we got useful.
We don't know if it was with a gun either.
We don't. They did not put the subsections in the PSI for us, so we just don't know enough about it. All I can say is that
there was a gun in this case.
Yes, we do.
Yeah, and do we know if the gun was operable?
We don't know because it was not recovered. And I do want to point out one thing. It appeared to me in my reading of the DA's brief that they said several prior robberies. I take it as 1 prior robbery where he got youthful offender, 15 years old.
There was an offer beforehand.
Yes, there was 4 years and he got 15 after trial. Obviously, the DA makes a point that you could run these consecutive because, 2 different victims taking of things from 2 people. That doesn't change my arguments. I still think 15 is harsh and severe. Mental health issues, strong family ties, 1 prior criminal conviction, the 1 youthful offender as well. No one's injured. Jeep recovered unscathed. He's acquitted of 2 counts.
We'll take a look at it.
Thank you so much.
Thanks, Council.
Good morning, Amy Wallensack on behalf of the people. Unless the court has questions about the other points of my brief, I'll address the same order that counsel just did. With respect to the legal sufficiency, this was unpreserved. And it's my position that looking at the circumstances in which the taking of this Jeep occurred show that defendant intended to deprive him of the Jeep permanently. He did abandon it. It seems to be 1 to 2 days later. I noted in my brief, there were several cases from the 1st and 2nd department involving similar carjackings, and there they found the evidence was legally sufficient when the car was abandoned minutes later. This was several days. The keys were snatched off of the belt of the victim and they drove off in it. It's not a situation where they made any affirmative attempt to return this Jeep to Mr. Rios. They left it 10 blocks away. While it's not in the record, I believe on Google Maps, it shows it's close to a mile away. And this was a man who was undergoing several health issues. It was displayed on the record that he didn't seem to have great mobility. So I don't believe that leaving the car 10 blocks away was somewhere that he was extremely likely to find it, especially when there's no evidence that he was ever in this area of the city. On the jury instruction, not only is it unpreserved in this case, and it would be inconsistent with the defense that counsel chose to primarily advocate for, and that defendant didn't commit the crime. But also the facts of this case are readily distinguishable from those in Blacknell and Medina. I believe it was Blacknell where it was unclear that an earring fell out during some sort of altercation, and the defendant never even made any attempt to take this earring. Like, that's distinguishable from when the defendant affirmatively takes the keys and speeds off in a vehicle and takes the property. There's not that kind of indecisiveness that led to the reversal in Blacknell. So we would ask that the court not review that issue in the interest of justice. With respect to the request for new counsel, defendant was given the opportunity to advance his claims in front of the court. The court listened and then adjourned to allow him to speak with his attorney further. It's a bit unclear on the record whether defendant was asking for more time to file a 3:30 or a 30:30. It seems like both motions were discussed at different times, and based on counsel's discussion of it at that second court appearance, I read the record to indicate that defendant was looking for a speedy trial motion, which at that point, given that the trial had already occurred, was legally impossible. He could not have brought a speedy trial motion at that point. The timing of this particular request strongly suggests a delay tactic, in my opinion, because it's at sentencing after the defendant's been convicted of several violent felonies. And also the court looked at the reasons that he was looking for a new attorney, and it was to file motions that really didn't have much merit. So it's my position that the court handled this motion appropriately and didn't abuse its discretion in denying it. And on the harsh and excessive issue, I recognize that this court has the ability to reduce a sentence, but it's the people's position that this sentence was appropriate. The court took into consideration all of the factors and
Well, the court knew, were there any factors that the court wasn't aware of at the time that the offer was made for 4 years?
I'm sorry,
In other words, when the offer of 4 years was made, right? And it was turned down. Were there other factors developed after that that could justify the court increasing from the offer? I get that the court's not wedded to the offer before trial.
Yes.
I'm fully aware of that. But we do have cases where when it goes quite a bit past that there's arguments of, there's a penalty for going to trial, right?
Yes, I don't believe any trial tax contention would be preserved here. And I think also looking at, the fact that the victim with the Jeep in particular was brought in from Connecticut and was suffering a lot of medical conditions at the time, I do think that was taken into consideration in offering this lower plea offer before trial, was to prevent the victims from having to testify and come in this situation. I also think, while the court is generally aware of what the case involves, I do think there is something to be said from watching the victims testify. I believe it was Ms. Rosario had testified about the impact of the robbery on her, and you can hear the terror in her voice in the 911 call that's made just minutes after this. I do think that there's an element of seeing the impact on these victims that the court gets from hearing the testimony that doesn't necessarily come through when you're considering a cold record before trial occurs. And again, I would note that the defendant committed the incident offense when he was on parole. He had violated probation, I believe, with respect to that other robbery case, and had a pretty serious criminal history for somebody of 20 years old. I think that the court took not only his background into effect, he could have been sentenced to a much higher sentence and received one that was lower. So I think all of that was.
Does the record show that? Does the record show that he was informed this when he turned down the 4-year sentence? He was on parole. He was going to be sentenced as a predicate, and he turned it down. Did the court go through that in the record?
Well, if this is respect to point 3, I know the defendant himself had turned down the additional time to consider the plea offer. I don't know that it was in the record that the court went through that on the morning of trial, but he was trying to glean whether the defendant wanted to plead guilty. And I believe there had been at least 2 prior plea offers in this case. And my understanding was defendant discussed both of those with his attorney and still wanted to go forward with trial. And I believe the defense that I didn't commit it and going for an outright acquittal. I think that would probably be more appropriate for a 440 motion, though, because there's not as much on the record as to what he discussed with his attorney. So I don't know that I can necessarily speak to that.
We'll take a look at it.
Thank you.
Thank you, counsel. 363 People versus Alfonso.
Morning, may it please the court, Sabrina Bremer for Mr. Alfonso. Based on a totality of the circumstances, Mr. Alfonso's waiver of appeal was invalid because it was not knowing, intelligent, and voluntary. There are a few issues here. First, the court did not confirm that Mr. Alfonso is voluntarily waiving the right to appeal. While it was in the written waiver, People v. Bailey from the Third Department notes that an invalid oral colloquy cannot cure A valid waiver, written waiver cannot cure a invalid oral colloquy. And importantly here, the colloquy and the written waiver are entirely silent on the issue of double jeopardy, which would
Does the court have to go through and specifically reference the double jeopardy defense here? I mean, don't we have a lot of cases out there that say there's no particular litany that the court has to use? There's no specific language as long as the court makes clear that, you know, you're waiving a lot of rights, not all.
Well, there's no particular litany required. The model colloquy does request that courts note to defendants issues particular to their case, so defendants are fully informed of the rights that they are waiving. And looking at the rights that Mr. Alfonso was informed that he was waiving and the ones he wasn't, he was informed that core constitutional rights like jurisdiction, speedy trial, the legality of the sentence, all of which go to the state's power to prosecute the case against him, those were all preserved. So as a
The people cited People versus Muniz in their brief, and then I looked in your reply, and you didn't address that case. You went to the CJI, the model colloquy, talking about the better practice. But it seems to me that we're stuck, after reading your reply, we're stuck with the better practice as recommended, but then we have a Court of Appeals case in Muniz. So how do we ignore Muniz, I guess is my question.
Sure. So I think that goes back to the totality of the circumstances in Thomas, where you have to look at the individual's case before the court, and there are certain issues that are more germane and others that are maybe less relevant. In most cases, a defendant doesn't need to be informed that his guilty plea would not extinguish his right to bring a double jeopardy claim on appeal. But in this case, it was really important, and there's no indication in the record that Mr. Alfonso understood that the waiver of appeal, not his.
So what you're saying, your argument is that these do become case specific, and you'd want us to find that the judge, because of the circumstances of this case, was required to articulate the waiver relative to the double jeopardy defense because of the specific nature of this case. That's what you want us to find.
Yeah, or under the totality of the circumstances. But yes, looking at these specific the specific facts of this case, while there doesn't need to be a per se rule that double jeopardy needs to be a right that defendants are apprised of when looking at if a defendant is knowingly and voluntarily and intelligently waiving the right to appeal, it is incumbent on the court to make sure that these case-specific issues are brought to the defendant's attention.
Was the judge in the first trial required to give an Allen charge?
So I think that, yes, they were. I was an abuse of discretion not to issue an Allen charge because it was specifically requested by defense counsel. Defense counsel wanted the jury to keep deliberating. And the jury notes, you have two jury notes that say, we are unable to reach a verdict. How do we proceed? And in Gonzalez, that was found to be a request for further guidance, not hopeless deadlock.
Well, they said they were hopelessly deadlocked, right? Didn't they say that in both jury notes?
No, so the first one was we're unable to reach a verdict. How do we proceed? And that's very similar to People v. Gonzalez, where the note was something we've been deliberating for a while and we're unable to come to a consensus. How do we?
Second note.
Sure. So our opinions are irreconcilable. Again, please advise. But then there's no polling of the jury to make sure that when they wrote this statement, it was, we are hopelessly deadlocked. Continuing to request testimony isn't going to get us anywhere. Because after they sent that first note of we're unable to reach a verdict, they did continue to request testimony. And it seems like deliberations did continue. And perhaps with the guidance of the court to affirm to them that it's okay for them to maybe even hear back testimony that they've already heard, to continue to evaluate these 7 different witnesses, that deliberations, they may have wanted to continue deliberations. But
Isn't that really the judge's prerogative, though, because he's the one there trying to decide whether it makes sense to give an Allen charge. He's not required to do it. So we need to get to an abuse of discretion on that, don't we?
Yes. And here it's Mr. Alfonso's right to have his trial completed by a particular tribunal as recognized by the Supreme Court. And I think heavy weight should be given to the fact that this is less than 2 days of deliberations. The court is only citing to the length of deliberations as the reason for not wanting to issue the Allen charge. And Mr. Alfonso in that case is the one risking a coerced verdict. And he is the one specifically requesting that the jury continue to deliberate on his case. So unless.
Thank you, counsel.
Good morning, Your Honor. Aaron Schwally for the people. I would submit that the appeal waiver in this case is airtight. On the merits, I would submit that the jury was deliberating for 6.5 hours on a case that had 7 witnesses. 5 said defendant was driving, 2 said the girlfriend was driving. If they can't find a resolution on that issue in 6.5 hours, they're not going to find it in 7.5 or 8.5 or 10.5. So I would submit that the court made the right decision here to declare a mistrial. Unless the court has any questions, I would rest on that.
No questions, counsel. Thank you.
Thank you.
Case 364, People versus Smith.
Good morning, Sabrina Brummer for Mr. Cordell Smith. The keys and credit card in Mr. Smith's pocket are not enough to establish control over Juliana Arnold's apartment.
Is that all there was?
Yes, I think that it was. He was inside the apartment and mere presence alone isn't enough. And he has keys and the credit card. But in People v. Siplin, there's very similar evidence presented of the defendant had keys to the apartment. He was dating the tenant. There was men's apparel in a dresser. And the Court of Appeals said that fell far short of the evidence necessary to establish constructive possession.
Let me, you know the record better than I do. Let me ask you this. The key in the pocket, was the key part of a keychain that was his keychain? Has that been established?
No, that was not established. There were keys in his pocket. And I believe a police went to the door after a battering ram had been used on it, and it did turn the lock. There's a picture of that. And the third department
But
did.
there's no indication as to whether or not those were his sets of keys or whether
No, not in the trial
the
record.
tenant's set of keys.
No.
Right.
What about-
Let me, just one more quick question. So the explanation that he had a key in his pocket, he also had a credit card in the pocket. Why does having the tenant's credit card in his pocket provide some indicia of him being there and, you know, possessing that apartment with her?
Sure. So because I think there's a total lack of other evidence showing that he frequently visited there or that he lived there. It seems to be a pretty casual romantic relationship. That morning, she could have given him her keys and his credit card and said, hey, do you want to go out, grab us lunch? I'll stay here. There's no witness testimony from police or anyone else putting him there on any other day. Looking at the items that were found in the apartment, his ID doesn't say he lives there. There's no mail found.
Is there cash?
I think he had cash in his pocket.
$218, I believe.
Sure, but people.
Is that the argument? Is part of the argument that because he had cash in his pocket and that amount that he's a drug dealer?
I would submit that that does not follow for me. I think people do carry cash, especially because looking at where the drugs and paraphernalia are found, it's all in concealed locations. There was no testimony that the drugs specifically belonged to Mr. Smith.
There's no toothbrush, there's no shaving cream, there's no, toiletries in the apartment that belong to him.
No, none of that is found. And then in People v. Williams, the evidence there was even stronger, connecting the defendant, who was a woman, to an apartment where drugs were found, where there was police testimony that there were a few items of women's shoes, and their police records indicated that she lived there. And this court.
People v. Williams was the case where they were watching the house hundreds of times, saw people coming and going, and the defendant in that case, female defendant, was there twice. And so there was there was no real evidence that she regularly frequented it. Here, I agree with the presiding judge about the toothbrush and the shaving cream, but we have the men's underwear in the armoire, same drawer, I think, where some of the drugs were found. Cocaine was found. The argument, there's an argument, I think, in the brief that, well, we don't know if it's his underwear, but see, that's where then the relationship comes in. That we're dating each other. I have her debit card. I have like that. So then, there's this sort of suggestion. Well, could it be a different man? I don't know if you're suggesting the police should have made him try it on. But
No, I'm not saying that.
in any event, right?
Sure, I'm not saying.
Doesn't that make it a little different?
Sure. So I'm not saying that he has to try it on, but looking at these other constructive possession cases where there's a dating relationship, there are cases where, there's 11.5 shoes in this apartment and the defendant wears 11.5 shoes. Or you have a neighbor come in and say, oh yeah, he's over there all the time. Like he basically lives there. That is totally absent. There's no,
Do women ever wear men's boxer shorts?
I think absolutely they do. You know, maybe Ms. Arnold sleeps in them. Like, I think that imputes a very specific idea of what their relationship must be like to assume that the men's underwear in this drawer belongs to Mr. Smith, that they have this serious relationship when police burst in and they say, oh, what's your relationship here? And he's like, he doesn't say, she's my girlfriend. What are you doing here? He says, I'm here time to time. We're seeing each other. Like, it's that to me does not rise to the level of he lives there, he's often there, they are in a serious relationship where he knows what she's keeping in her coffee table, in the dresser, in the closet.
Can you comment on the body cam video?
Sure.
We have him saying, before anybody says anything, and he says it quietly, but he says, I know it was drugs, obviously, but what was the warrant? And I think Officer Tremblay said, I'm sorry. And then the defendant said, what was the warrant for? Like, in general, anybody know?
Mhm.
And then somebody said narcotics, and he says, oh, I know narcotics, but is it sale or is it, he's sort of taking control here of the situation, even though he's sitting handcuffed on the couch. It's just, tell me how we should view that.
So I don't think that is dispositive at all, because this is, again, it is, the police are in there. He appears to be reading a piece of paper that may in fact be the warrant when he's asking these questions. I don't think that's an unreasonable clarifying question to be like, what is the basis of your warrant? He may know something about Ms. Arnold or other men that she's dating or other people that she's associated with, and still, you know, again, looking at, it has to show constructive possession over the area where the contraband was found. And that is just not established here under any prior case law. Is access alone sufficient? And I don't think that the relationship between him and Arnold, especially in light of People v. Siplin, where the Court of Appeals, there was a much stronger relationship. They found that plainly fell short. So
Thank you.
there are any, okay, thank you.
Good morning, Mayor, please the court, Regina Harper for the people. In this case, the people did submit evidence that was legally sufficient, and the verdict was also not against the evidence. As to legal sufficiency, the evidence has to be viewed in a light most favorable to the people. And when it comes to weight of the evidence, the viewing of the evidence has to be done in the light of the elements of the crime. I respectfully submit that we have all of that. As to constructive possession, we have the testimony that comes from the defendant, his own admission that he stayed in this place from time to time. He was seeing the co-defendant. He was found at the time of the execution of the warrant. He was found in the bedroom. Interestingly enough,
Counsel, let me ask you a question. So if somebody is seeing someone else, right? And are they obligated to ask the person who's the tenant to allow them to go through closets and drawers and everything to make sure that there's no drugs there, so that in case the police arrive, they're not going to be charged with possession of the drugs? And if so, isn't that unreasonable?
that would be an unusual scenario. I agree with you, Your Honor. However, here we have more than just seeing someone from time to time and perhaps romantic relationship. We also have control over this house because the keys were found in the defendant's pocket.
Your opponent says it's as reasonable to believe that he has the keys and a credit card because he was asked to go out and grab lunch or coffee, whatever it was, and come back because maybe she's going to jump in the shower or do something. That sounds like a pretty reasonable excuse as to why he has keys and a credit card.
Well, that was not how the evidence came in. This is something that the defendant now suggests, but this is not something that was ever presented at
What was
trial.
the explanation for why he has the keys and the credit card?
They were in a relationship and he has dominion and control over this place. The key is on a keychain.
When people are in relationships, is it normal for one person to give the other person a credit card to keep?
It is, but interestingly enough, he also had, well, They can, yes.
We're dating now, so here's my credit card?
Well, her credit card was found in his pocket, so.
And is that normal in a normal dating every now and then relationship that we're dating now, every now and then, and I'm here periodically, so give me a credit card?
In this.
Seems odd, right?
Well, in this situation, the credit card was found in his pocket.
I understand that, but what you're saying is part of the explanation for that is he has dominion and control over the apartment because he has a credit card in his pocket that belongs to her. And I'm not following the logic there. I'm missing
So
that.
there's a relationship between the two of them, because between the defendant and the co-defendant, which is evidenced by the presence of her credit card in his pocket, by the keys. Obviously, someone who has keys to the premises can come in, open the door. It was established during the trial.
We don't know if those are his keys. They could be her.
I agree, this was not exactly established in the record. The keys
Wasn't that all we have before us is the record?
correct. The keys that are shown in one of the people's exhibits, they also have some other cards attached to them. So that just shows that someone who had possession of the keys also had other cards, their membership cards or discount cards that were attached.
Do we know that those membership cards or discount cards were his cards? Is that established in the record? Or were they hers?
This was not established on the record. However, Your Honor, I would also like to point the court's attention to the statements that the defendant makes. As he is.
Let's go, I'll let you get to there, but let me ask one question.
Yes.
Is part of your argument on constructive possession that he had $218 in his pocket? And that's an indication that he was a drug dealer?
This was something that was argued below. He was ultimately convicted of possession of the drugs, not possession with
Is that a
intent to sell.
dollar amount, the $218? Is there some amount where anything above a certain dollar amount, we can assume that they're a drug dealer because they're carrying that amount of cash on them?
It's an inference that can be potentially drawn. I'm not sure if this was something, it was argued in a closing statement by the people. But certainly that is something that the inference that can potentially be drawn.
Okay, go ahead. I interrupted your argument. Go ahead.
Thank you, Your Honor. So when it comes to his statements, knowledge of the drugs, they are very interesting statements when he is trying to ask the police officers as to what is happening there. His demeanor and the questions that he is asking are, as argued below, indicative of consciousness of guilt. It's not someone who is surprised. Oh my God, what's going on? There's police in the house. No, he is. When one of the officers mentions that they're there because of the narcotics, the response from the defendant is, "Oh, I know narcotics." He then continues.
As your opponent says, he appears, and I watched the video, he appears to be looking at a piece of paper. If he's looking at the warrant, do we know if the warrant uses the reference narcotics?
The warrant was not introduced as evidence.
Wouldn't it be normal that a search warrant would indicate that maybe narcotics is, if that's what they're looking for, that that's on the warrant?
Perhaps. What would not be
That would
normal.
explain why he says, well, I know narcotics. In other words, I have the warrant for, I know narcotics. That wouldn't be consciousness of guilt, would it?
Even if so, if he is really not guilty of anything, why would he ask whether it's a suspicion of mere possession or sale? That pointed question shows obvious knowledge. Oh, is it possession? Is it only a possession, or is it he actually uses words, no sale, no nothing, just suspicion of narcotics? Your Honor, I would submit to you that this is consciousness of guilt. And that indicates the knowledge. Thank you.
Thank you, Counsel. Case 365, People versus Wilmette. Mr. Keene, can you hear us?
I can. Is the
Very
court-
good. We can hear you clearly.
Perfect.
Mr. Green, can you hear us?
Yes, I can. Good morning, Your Honors.
And we can hear you very clearly. Very good. Please proceed, counsel.
Good morning. May it please the court. Brad Keem. I represent Christopher Wilmette. I'm going to start with the failure to correct the pre-sentence report. The pre-sentence report included multiple claims that Wilmette sexually abused another person since she was 9 years old, and a claim by an investigator that he was a high risk for children. Defense counsel asked for the striking of the references because he was acquitted. The trial court's denial of that request ignored the other important uses of the pre-sentence report. As the court well knows, the pre-sentence report is the most important document at both the sentencing and correctional levels of the criminal process.
This will follow him throughout his time in prison. Is that right?
That's right, Your Honor. And permitting this prejudicial information to stay in the pre-sentence report, it impacts his SORA hearing, it impacts parole hearing, treatment, potential treatment while in prison. So we would ask that it's just not about sentencing. So we would ask the court to order the striking of that.
We'll take a look at that.
My next issue is the persistent felony offender. So initially the people offered Wilmette a 7-year term. It went down to 6.5. And then during deliberation and after CK, the victim here testified, they offered 7 years again. So it's a little inconsistent, I think, for them to now, have lifetime as a max here. In terms of his history of criminal conduct, he had a series of grand larcenies as an 18 and 19-year-old. As a 23-year-old, he made some brash, cocky comments about marijuana, but in actuality, he was never committed another marijuana offense and actually did treatment. He has a brass knuckle belt crime that very minor, no actual violence seemingly involved in this. It's just not a persistent felony offender history. And then when you look at his history and character, he's a union roofer. He has regular contact with his children. He actually had primary custody of his daughter. We'd ask this court to substitute the trial court's discretion and find that Mr. Wilmette is not a persistent felony offender. We raised several other issues in the brief, and I'm happy to address those if the court has further questions.
No other questions, counsel. Mr. Green?
Good morning, Your Honors. Addressing the persistent felony offender sentence, it's obvious that a prosecution likes certainty, and there's no greater certainty than a negotiated disposition of a plea and a maximum sentence without the persistent felony offender status, which was something in this case that was discussed before the trial. Yes, this defendant didn't have a history of violent crimes or sexual assaults, but this crime in and of itself speaks volumes about the risk that he does pose, with all due respect to the acquittal in the other case involving the other victim. The sentence in this case as a persistent felony offender, in view of his history from his adolescence right through the time of this crime, the commission of this crime, shows no real break in his criminal behavior and is warranted under these circumstances, even if this is his first felony offense. This is a 30-year-old male who took advantage of a 14-year-old female in a very vulnerable situation. And as such, the court's fully familiar with the record. We do believe that the sentence is appropriate under the circumstances. To address Mr. Keem's point on the pre-sentence report, the court didn't take into consideration, obviously it was aware of the background. To the extent there are any references that suggest something that isn't supported by the record, we'll leave this to the court's sound discretion as to any modifications of the pre-sentence report. We do respectfully understand the seriousness of the pre-sentence report itself. So with that in mind, if there are no other questions, the only other thing I'll go ahead, Your Honor.
I have one question just regarding the ineffective assistance of counsel claim.
Sure.
Counsel didn't touch on it, but
yep.
The jury selection.
Yeah,
you have almost no questions asked at all. This little joke about anybody going to the Bills game tonight or the football game, and then he makes this comment, I'd like you to look past what the legislature decided to name this particular charge, almost implying that doesn't agree with statutory rape as a concept at all. It struck me as being surprising.
So
your
I
comment
would,
on that?
yeah, I understand that the tone certainly drew appellant's attention, especially on the run remark. I think the manner in which this case was tried by this attorney was not to be overly confrontational, to be likable to the jury. This is a very serious crime. I don't think he tried to minimize that this was a serious crime or in any way negate the fact this is one of the most serious crimes when you're involved with a 14-year-old victim. When you look at the exercises of his challenges during jury selection, both the cause challenges and peremptory challenges, even if his questioning was minimal, he was very effective in removing jurors who potentially were removable for cause and used the proper exercise of peremptory challenges. So on the whole, I understand that, especially that one comment might be a little off-putting, but this was counsel's folksy style, as it were, throughout the trial. And he was successful to the extent this was a 10-2 verdict, which became a point in the trial, as your honors know, that two of the jurors didn't want to convict, even though this case was brief, and even though the traumatized victim gave very minimal testimony, which in its totality actually probably exceeded the sum of its parts. And since it's not been discussed today, I think the record does speak very well to that. And I do want to point out something that I know is in the brief and in the record, but I'd add that it wasn't just the victim's DNA to the exclusion of 320 billion people in the population and the defendant's YSTR profile. It's seminal fluid. So it's not just DNA and it's male DNA, it's seminal fluid in that mixture with the victim's DNA in this case. And the only other thing I'd add, which is an issue as to ineffective assistance in the Allen charge, I know, again, wasn't discussed. The court actually, when I went back and I reviewed the entire record in this case, gave proper instructions that the jurors weren't supposed to relinquish their views. So to the extent that it didn't give an Allen charge, it actually gave a more appropriate charge saying, look, we're not done here. We want you to come to a verdict, but we don't want you to relinquish your views and just come to an agreement so as to end the case. Otherwise, I understand that, the record speaks pretty clearly for what happened here. And if there are no questions from the court, be happy to then rest on our brief.
Thank you, counsel.
Thank you, your honors.
Case 366, People versus Akbar.
People's appeal is moved.
Very good. Thank you, counsel. Case 367, Jiggets versus Thomas Sr. The appellant, I believe, is submitting. I'm sorry?
It's only the AOC for now.
Yes. Okay, very good. Thank you. Counsel Mareka, can you hear us?
Yes, Your Honor, I can.
And we can hear you. Counsel Jesse, can you hear us?
I can, Judge.
Very good. Proceed.
Your Honor, thank you. Mindy Marenka for the Child Pretty T. As the court is aware, in my papers, I would ask the court to uphold the trial court's decision. There was no change of circumstances alleged by the petitioner appellant mother relative to even asking for a change of circumstances and relocation. Not getting along or poor communication is not a change of circumstances. Further, the appellant mother did not meet any of the factors of relocation under Tapia or any of the series of cases after that. The court properly properly considered all of the circumstances under that case law, the distance of the relocation being requested and how that would affect all of the children. But my client is specifically on my behalf. Specifically, there were siblings that lived with the father here in Western New York still that my client would have a very hard time seeing and moving many, many states away. The appellant mother further had no specificity in what would improve for the child with this relocation, aside from being closer to maternal family members. There was also no specificity in her own plans for her personal enhancement, aside from wanting to go to a college or wanting to have educational benefits there, and not clearly looked into all of those differences. Most importantly, this was not in the best interest of the child to relocate and to lose the consistent access.
Well, it may have been, but what you're arguing, I think, is that the record doesn't demonstrate any effort by the mother to put forth evidence that, one, the school system was better there, that the mother that she was going to go to live with could financially afford to keep the kids there, and the condition of the home, and how long-term that was going to be. Her college plans were not at all specific, not even the name of the college or the course of study she wanted to go to. So it very well may have been in the best interest of the kids to go there, but we just don't know that on the record before us. Is that right?
That is right. I think more clearly that the trial court properly assessed that what was before them in that evidence led them to state that it's in the best interest of the child not to relocate.
Thank you, counsel.
Thank you.
Judge, that's accurate. This was a 2-day hearing that mom testified at, and there's simply zero evidence that the move would enhance this family in any way, educationally, emotionally, financially. On the adjourned date, when they came back for the second day, 14 days later, mom did have some details. She was able to provide some details, but it was clear that she did that after having those questions on the first day of testimony. And even her answers then were not substantial. She was attending, I believe, Genesee Community College. She said that she'd like to transfer, but she didn't know where she was going to transfer. She didn't even know if she would qualify for financial aid in the other state or any sort of temporary financial assistance. She refused to give information about her mother's income. She simply said her mother would help her. And I think most overwhelmingly, for me, for this child, the younger of the two siblings, Indigo, less contact with dad, less frequent contact with dad, and the two siblings in Rochester would be a serious loss for this child. Even if the number of days per year were equitable, right now she sees that family, that part of her family, 3 weekends a month. And dad was very clear that he wouldn't be able to afford bringing the child back and forth from the Carolinas enough to even approximate that. I think the record supports family court's decision.
Thank you, counsel. Case 368 is submitted. Case 369 in the matter of Domenico H.C. Mr. Fox, you're the only one appearing today. Do you want to be heard?
Yes, Your Honor. Thank you. I don't know if you can see me, but I
We
appreciate.
can.
Thank you. Your Honors, I would just say that we think this is a very straightforward case. This is a parent who placed the child at risk, which she took the child with her to commit a crime. She did not have an adequate short-term or long-term plan in the very foreseeable event that she was detained. And our position is that that's not how a reasonable and prudent parent would act. If the court has no questions, we would rest on our brief.
Thank you, counsel.
Thank you, Your Honor.
Case 370, Bennett versus Garcia Ramos. Proceed, counsel.
Good morning. Robert Flint for the defendant's third-party plaintiffs. Rather simple matter before the court this morning. It is a piece of litigation with 2 motor vehicle accidents. The focus of this appeal is the second one. In that matter, the The third-party defendants moved for summary judgment, and it's our position that
The two accidents happened, what, within a month's period of time?
24 days. Correct. And immediately after the second accident, Mr. Bennett reported to the police that he had some neck pain and some back pain, and he did not seek treatment that day. But the next day, he went to DeGraff Memorial Hospital. He presented with 10 out of 10 pain regarding his cervical spine, low back, and some other areas of his body. Some diagnostic studies were ordered, and he was released that day. The other set of facts we have are from his deposition testimony and his bill of particulars. And he testified that I wasn't hurt in the second accident. His bill of particulars says the same thing.
On that point, the respondents cite a bunch of cases on look at page 18 of their brief, but a lot of them are sort of obvious things that a plaintiff would know, broken jaw, that kind of thing. So, but he has one in particular, Chintum versus Fenelus, First Department, 2009, where a plaintiff talked about how the low back injury, the lumbar injury, wasn't related to this accident, was related to my prior work accident. And the First Department held, I think, that the defendant wasn't required to submit medical records on that. They could basically trust the plaintiff. How's this different than that case?
I think the findings of the DeGraff folks that examined him found specific findings. I think it was lumbar spondylosis was found.
This is the day after the second.
This is the day after the second accident. And I think what we have in this case was Mr. Bennett saying, I wasn't injured at all. Nothing changed. Well, we know that's probably not the case, because if nothing changed, there wouldn't have been a reason to go to the hospital after the second visit or the second accident, which is what he did. And so these are, ironically, the facts regarding the second accident come from Mr. Bennett, not my client, arguing that he said something different or something that contradicts my client. The two stories, the two versions, one being injured, two not being injured, I think is an inherent question of fact that can't be resolved by a decision of the lower court. Otherwise, we're engaging in issue determination as opposed to issue finding at summary judgment.
So, counsel, let me just be clear on really what's playing out here. A plaintiff it seems, is limiting their theory of the case to the first accident.
That's exactly what's happening.
Right? With the motion decided the way it was decided, is that going to limit your proof at trial to the first accident, or will you still be able to bring in the evidence? Say an expert comes in and says, no, the second accident caused a lot of these injuries.
That is exactly what I anticipate. Due to the timing of this particular motion for summary judgment, discovery was not complete. We don't have a trial date. I would make every effort on behalf of my clients to bring in the second accident for a variety of reasons.
So your concern is that if the summary judgment motion is upheld, that won't be before the jury because that case is dismissed and it's not a viable case.
Exactly. So our position, it should be there from a factual standpoint. And it also, if we're barred from talking about it, prejudices my client. So
very good. Thank you, counsel.
Thank you.
May it please the court, Henry Masha, attorneys for the third party defendants, Jennifer and Michelle Steele. The third party plaintiffs here don't seem to argue that they raised an issue of fact. They only challenge my client's initial showing, the initial proof that we submitted. And in this case, the plaintiff's testimony and the bill of particulars by itself is enough. That is, the plaintiff testified about his experience and what he felt before and after the first and second accident. And that by itself is enough to establish our prima facie burden of proof. But we have more than the plaintiff's evidence here as well. The plaintiff's testimony is corroborated by numerous other undisputed facts. And I'll just walk you through them. After the first accident, it was so severe that the plaintiff struck the steering wheel with his chest and bent the steering wheel forward. Immediately after the accident, he felt severe pain, pins and needles down his back. His whole spine hurt. He was taken out of his vehicle in a neck brace and put on a stretcher and taken to the hospital. And then he was out of work, and he was still out of work at the time of the second accident. And now let's compare that to the second accident where the airbags didn't deploy. He didn't go to the hospital and he went with the tow truck to the impound yard. And he testified that his pain was the same before and after the second accident. So, and there's a reason why he went to the hospital the second time. He testified that he went for chest pains, and it turns out that he had pneumonia. And that's why he went to the hospital. But more than that, the third-party plaintiff's own evidence corroborates the plaintiff's testimony. On page 317 of the record, I'd encourage you because we talked about CT scans earlier, the cervical spine, they specifically say that they compared the two CT scans from the first accident, after the first accident, and after the second accident, and quote, there was no real significant change. And
he does have some disc disease present.
Sure, of course, but that could be from degenerative. His testimony is that he was injured in the first one, but the fact that there's no change from after the second accident is significant. The medical records also describe the accident as minor and that he had pneumonia. And what's even worse than that is that the third-party defendant selectively chose what medical records to submit, and they left out the one on page 386 of the record, which as early as September 27th, 2018, which is 6 days after the second accident, the plaintiff's doctor says that all the injuries are related to the first accident. And that's not made in contemplation of litigation. That's just the doctor's opinion. So the bottom line here is that there's nothing for a jury to decide with regard to the steals. The only reasonable inference from the undisputed facts is that the plaintiff was injured in the first accident and not in the second.
Thank you, counsel. Case 372, Barnhart versus County of Monroe.
Good morning, Your Honors. May it please the court. Maria Rohde for the appellants, County of Monroe, and John Bringawa as Monroe County Attorney. The trial court here failed to apply the arbitrary and capricious standard to appellant's determination. The Monroe County Code provides for defense and indemnification when a person considered a county employee under Chapter 39 of the code is sued for something done within the scope of their employment.
Okay, let's go through that.
Yes, Your Honor.
He is an employee.
Yes, Your Honor.
Okay, and this is whether or not, the whole case really is, what was she furthering at the time that she made the statement?
Yes, Your Honor.
Okay, and she gives an explanation of what she was furthering. And I'm not sure what your explanation was, why you denied it, what was there, what were the merits of the denial of her claim to begin with?
Your Honor, the basis for the denial was, and if I may back up, Your Honor, if I may for a moment, the record that was before the appellant is important here, because we've heard a lot of after the fact explanations from respondent, but the record that was before the appellant when he made the decision was the press conference, the 2022 press conference at issue, and then the underlying defamation complaint against the respondent. And based on the fact that there was no reference to any county business, the respondent was not appearing there in any county capacity. And in fact, it was all about the city of Rochester, the Rochester Police Department, calling upon the Rochester Police Department and the city of Rochester to conduct certain investigations, but absolutely no nexus to county business.
Okay, except for that, where this all took place is within the county.
Yeah, yes, Your Honor. But a geographical nexus is just not enough of a nexus to fall within the scope of employment for county business.
What about her constituents? She was a county legislator, but most of the people she represented lived in the city. So her constituency, it was sort of both, right? I mean, she represented people in the city, people in the county, so.
Your Honor, that was one of the after the fact explanations that was brought up by respondent. The fact remains that the record is that none of that was ever said at the press conference. The respondent never said, I am here because I'm speaking on behalf of people that live within my district. I'm here as a county legislator on behalf of my constituents. None of that was ever brought up in the press conference.
Okay, but she said she was there because she was called by the acts. She called on an investigation for the fire department and things of that nature. And that certainly isn't what, a person, an average person would say. Isn't that something that a legislator would say? I call upon, so-and-so to do an investigation of the fire department.
Your Honor, that's what a city council person might say if they're calling upon the Rochester City Fire Department to conduct an investigation. And it's what a county legislator might say if they're calling upon someone in the county to do something. Here we have a county legislator that was calling upon the city government to act. And in fact, there were regular citizens at that same press conference saying the same things.
She was calling upon, calling for the investigation, right? Arguably on behalf of her constituents.
Possibly, arguably, but she did not say that. And so I want to bring the court back to the fact that this is an arbitrary.
Let me just be.
Yes, Your Honor.
I'm trying to understand it. So is your argument that she wears two hats, at least two hats? One as a county legislator and one as a private citizen?
Yes, Your Honor.
And when she was there as a private citizen because nothing she said tied her into her role as a county legislator.
Yes, Your Honor.
So that's essentially your argument.
Yes, Your Honor.
Okay, very good. I'll take a look at that. Continue. If you want. I mean, I don't mean to.
No, thank you, Your Honor. So I just want to remind the court of the arbitrary and capricious standard here that what the trial court did here was what a court that's reviewing a sole discretion decision in these circumstances cannot do. And that court supplanted its own opinion for that of the county attorney. It's our position that the standard of the county attorney's decision had to be rooted in fact and law was clearly met. He has two well-reasoned letters that set forth these reasons. Respondent has raised the issue of in their papers of the duty to insure. The duty to insure is very broad. First of all, I just address that by saying that it's the duty to insure standard is a guide. It does not replace the arbitrary and capricious standard that the court is for review. But also I would argue that defining the scope of employment as having any connection to county business is a very broad scope. I would argue it's the broadest that was possible. And that was what was applied by the county attorney.
But are you defining county business as financial? It gets back to what Justice Bannister was asking. What about the residents? I mean, and the thing that I'm concerned about is if you have a concern that residents have because of something that's been reported in the press, and it could be something, private. There could be like a health concern in the community because a drugstore released some kind of a drug that was tainted or something like that. Nothing to do with county business, but the residents are concerned. And you're a publicly elected official representing the residents. The residents have a concern. You want to have a press conference to address a concern by residents. It would seem to me that what you're suggesting is that can't happen anymore. If it can, that you're on your own at that point. You're not within the scope of your duties.
Yes, Your Honor, that's two points. And no, it can happen. We're not trying to chill the ability of any public officials to say something publicly. But yes, it's correct that there is a line as to when the county is going to be the county is going to have to pay legal costs for anything that you say, and there has to be a line. And again, I reiterate that during the press conference and in the complaint, there is no mention of this is a county business, this is a county concern. I'm out here for my constituents. This was the city isn't investigating. The city didn't do things that were right. Quoting the general orders of the Rochester Police Department, it is a completely different entity. It is controlled by a completely different government. There was never any request by the county to take any action at the press conference or afterward.
We'll take a look at that, Council. Thank you.
Thank you, Your Honor.
Morning, Michael Higgins from Legislator Barnhart. First, I'd point out that the court did apply the arbitrary and capricious standard. First, I'd like to address the record and what is or is not in the record. If you look to the record at page 73, the first denial just says there's nothing in the complaint about the county. It doesn't address the full standard, which is that it has to have either occurred in fact within the scope of employment or be alleged. And the first denial is just, it's not alleged that but in the complaint that she was acting within the scope of her employment. And then if you go to what happens next is that Legislator Barnhart makes a subsequent request, and that's at R82. And in our subsequent request, Legislator Barnhart talks about all of the things that the county says aren't in the record, that these people are her constituents, that it happened in her constituency, that she wanted an investigation, that she was acting on behalf of her constituents to induce that investigation, that the firehouse was located within her legislative district. So those things are in the record. And also that Monroe County has an interest in the equitable public employment of people both in the city and the county, and that there's a commission on that. And they admit, I allege in the petition, or Legislator Barnhart rather alleges in the petition, and then the county admits that there is a commission for this purpose. So if it's impermissible for the county, if it's not part of the legislator's duty to care about equitable employment within the city of Rochester, I don't understand how the county could participate in a commission for that express purpose. It has to be within the scope of her employment.
Let me ask this question, Council. I mentioned that wearing the two hats, and it strikes me that the legislator in this case, your client, in calling the press conference, would have to be wearing the legislative hat, because the press isn't going to show up if citizen Jane Doe calls a press conference. And so if that's the case, they're there because she's a legislator and elected official.
Yes, I mean,
we'd have to conclude that she took that hat off and then became a private citizen, wouldn't we?
No, I don't think you need to make that distinction, because first of all, I think you're correct that the reason that she's there is because she's a legislator. The reason that she was sued in this action is because she's a legislator, even though the plaintiff pled it differently to plead, to attack her individually. But yes, she's there because she's a legislator. The comments about her, the subject of interest is because she's a legislator. And even if you don't think that part of what she's doing, if part of what she's doing is her individual role, part of what she's doing is certainly in her legislative role. If you took the press conference out of it and her constituent called her and said, I've been discriminated against by the city of Rochester in my employment, and then Legislator Barnhart called the city of Rochester and said, please conduct an investigation, that would be within the scope of her employment. That's what W.E. Rest tells us. That's an act that's within the scope of her employment. It could, to your point, Judge Nowak, be a private employer. Her constituent calls her and says, some private employer within the city of Rochester is discriminating against me, and she calls upon the appropriate authorities to interact with that. Also, specific governments don't act within a vacuum, right? Monroe County, the city of Rochester, they're intertwined. The county admits that in their answer to the petition. She represents the people who live there. The people who live there are residents of the city of Rochester, the residents of the county of Monroe, and they want their needs addressed. I also think that if you look particularly to the powers and duties that are set forth in the charter, they're incredibly broad. The county complains that there's really no limit. That's because legislators do a lot of things. The first clause in the charter is that the legislature has the powers and duties now or hereafter generally conferred outside the legislature and on boards of supervisors, and all powers necessarily incidental thereto. And then it goes on to say that the county legislator is the legislative, appropriating, policy determining, governing body of the county. It's a big job. There's a lot of things that you do. And then it has a non-exclusive list with two provisions that are savings clause. The third provision says you get to exercise all powers of local legislation in relation to enacting, amending, or rescinding local laws legalizing acts or resolutions. The county can make resolutions about whatever they want to, that the Red Wings are the greatest baseball team in the world. That's a legislative act. Speaking about it is within the scope of her duties. And then also sub 14, which I don't think I cite in my papers, but also says to determine and make provision for any matter of county government not otherwise provided for herein. So the powers are incredibly broad of the legislature. There's no description of a legislator's job in the record. The county attorney points to this statute, but this statute is non-exclusive. And that's why I point, and because it has those reservation clause, that's why I point to the other authority about what legislators do, including Dolores. Thank you.
Thank you, Councilman. Case 374. I thought we're keeping 373 to the end.
Oh, okay. I didn't know.
We're gonna hold 373 and we'll take 374 out of order. 374 Vermillion versus the Roofing Guys, Inc. Council, can you hear us?
Thank you, Your Honor. James Special for the
Well,
roofing.
hold on a second, Council, your microphone is not working very well for us. Very terrible.
Can you hear me now, Judge?
Darrell, can you pull back from the microphone? And what do you do? That'll help.
Or let me see here.
That's gonna be difficult to hear you out there, Council. It's really funny process. I'm gonna suggest talk into the court. Take your argument by phone.
Oh, okay, yeah, I'm having trouble hearing you as well. I don't know why.
So we'll take your case next, but we'll talk about another case while we set up.
Great, thank you, Judge.
Versus Buzzowitz MD.
For defendant Dr. Rollins. It's a very narrow issue we're going to talk about is so many issue crossing clause with so many judges pushing for just one defendant. The patient was diagnosed with stage 4.
Here.
He can invite a team and bring the office into the office because of our work. So we can invite space for
Let's get this stuff. The discussion. What's the price of cancer? Let's just say that. Look at the results. There would never been an opportunity to early treatment, maybe an opportunity for extension of this young man's life.
Not in this case. And the other thing, the reason we're really for some of the revenue motion, the issue Psychology experts indicated that this patient's cancer was reflected to medical treatment. Said that once the patient was diagnosed, they gave the patient treatment to respond. They died very quickly afterward. And that expert says the same thing. Both experts saw how treated thousands of patients across to the same level. This patient was a diagnosis. Responded to treatment. Patient didn't. Same condition. Personally, you have these statements of the two experts. Sometimes they're really tricky. Why you treat them? Our patients were not done. Then they go to the oncologist and the oncologist says this is incurable. There's any treatment you can do. So change anything. That's the situation we're talking about here. Is reflecting to medical treatment. So in other words, if he was reflecting to medical treatment at the time of diagnosis, but he also reflectable to his reflectory medical treatment months earlier. To do with so reflective in the patient's 6-year-old. I would think that this patient's case can respond to treatment. But it was completely about his effect over the disease itself. Those are the two issues. One patient first saw my question was state for next book. Question was it reflecting to medical treatment? In these cases, was both experts agree. This is my emotion. There's no question. This is what we know with emotion. Further, it can be expert. Your Honor.
Anything further, counsel?
Just one further thing. The plaintiff's expert specifically mentioned nothing with regard to any delay after March of 2020. So there are places when they talked about the deviation aspect of it, when they said it had to be performed in January, February, March. Nothing after that. So even if the court concludes that there's a question of fact from January to March, there can be none after that. And as I asked the lower court, it should have been a partial summary judgment at least with regard to any treatment dates after that cutoff line. And with that, unless there are questions.
I do have one question.
Yes, sir.
And I'm going to refer you to the record 793, 794, plaintiff's expert. I believe I have this right, and I'd like you to respond to it. Plaintiff's expert, I think, is saying it is likely that it would have revealed the subject colon cancer, meaning had he gotten the colonoscopy, leading to a diagnosis at a significantly earlier stage and at a time when curative treatment would have been available. Isn't that contrary to what you're saying?
Let me say two things about that. Number one, the fact that their expert disagrees with himself to say that the expert says, I agree that this patient had stage 4 incurable cancer as of the first visit. The fact that later in that expert's affidavit, the expert disagrees with himself does not raise a question of fact. The fact of the matter is our expert and their expert agree that it was incurable stage 4 as of the first contact. The second thing is if you go on in that where you're reading there, if that is the oncologist, they mentioned that diagnosis prior to March of 2020. So it goes to the argument that I just made, Your Honor, that nowhere did they mention any causal relationship to any alleged negligence that happened after March. So at the very least, this has to be a partial summary judgment, but it's my argument that it should be a full summary judgment for the reasons that I've articulated.
Thank you, counsel.
Thank you.
Good morning. May it please the court. My name is Mary Langen. I'm from the Porter Law Group, and I represent the plaintiff respondent, Rachel Finnegan. This case involves a 29-year-old man with Crohn's disease who died of colon cancer after defendants failed to provide adequate counseling to him on the importance of the surveillance colonoscopies that were just discussed. The lower court found genuine issues of material fact on causation. As Mr. Patton alluded, the issues are narrow, and defendants have appealed solely on the issue of causation, not on negligence. Mr. Finnegan was diagnosed at 12 years old with colon cancer, with Crohn's disease, which placed him at a higher risk for developing colon cancer, supporting the importance of undergoing surveillance colonoscopies to surveil for the development of that disease. Mr. Finnegan, importantly, had been misinformed by his prior gastroenterologist that colonoscopies could be safely avoided if he was asymptomatic. So if he was feeling well, that he could avoid or he could delay undergoing surveillance colonoscopies.
Let me just stop for a second and let's get to the initial meeting with Dr. Rollins.
Sure.
Right? And so I think the record, I don't know that there's a dispute on this, but I think at that time, Dr. Rollins even says in looking over his records that he didn't have a record of counseling the plaintiff relative to the heightened risk of colon cancer for somebody who was diagnosed at a young age with Crohn's disease.
That's correct. Dr. Rollins admitted at his deposition testimony.
And he didn't recall one way or the other whether he said it, but he said the record clearly doesn't reflect that.
Correct.
And your argument is, had he been counseled, there wouldn't have been a long delay because had he been properly counseled, he would have gone in and got the colonoscopy. Now, we don't know that, but the argument is presumably he would have had he known the risk. That's your theory of the case.
Right, and we do have the support from the testimony of his wife, who would testify at trial about his character and how much he cared for his family and his children, and how if he knew he was at an increased risk for developing colon cancer, he certainly would not have prolonged or delayed getting that colonoscopy.
Let's say that we're past that now.
Sure.
Your opponent says it doesn't matter.
Right.
Because it's end-stage colon cancer, it's not curable, and detecting it early would have not resulted in any different outcome. Treatment, even if it was prescribed, wouldn't have benefited him at all. How do you respond to that?
Sure. Thanks, Your Honor. So defense counsel's argument that there's a 0% chance, that was his expert oncologist language, that there's a 0% chance of survival. That claim is directly contradicted by both medical literature, which was cited by our plaintiff's oncology expert, and our expert's own clinical experience. So our expert cited statistics and publications showing up to a 45.5% 3-year survival rate for patients with stage 4 colorectal cancer when appropriate early intervention occurs. So, and then our expert also cited 2 instances where he's personally treated other patients with stage 4 colorectal cancer, and when diagnosed early enough, that they've responded favorably to treatment. Now, it is our opinion, as Justice Greenwood stated, that this is a classic battle of the experts, that we have 2 experts, our gastroenterology expert who initially opined on causation, and then our oncology expert who expounded upon that and supported that further by stating that not only if it were diagnosed, it would have been a lower tumor burden, and that there could have been curative treatment options available, including potentially a curative surgery. But that, moreover, all of that said that there would have been a chance for increased life expectancy, more favorable treatment.
How long did he live after the initial appointment with Dr. Rollins?
So the initial appointment was January 2020, and he died in February of 2021. So he lived 13 months after the initial appointment. And after the initial doctor's appointment with Dr. Rollins, there were several other patient contacts. It wasn't just 2 doctor's appointments. There were phone calls, there were messages, intra-office messages. There were opportunities that Dr. Rollins had to be able to inform Mr. Finnegan of his increased risk and why it's so important that he gets those colonoscopies.
Does the record reveal there was a direct telephone conversation with
That's
Dr.
correct.
Rollins and the patient?
In April, that's correct.
Anything further, counsel?
Unless the court has any questions, there's nothing. I have nothing further.
Thank you, counsel.
Thank you.
We're going to recall case 374, Vermillion versus the Roofing Guys, Inc. Counsel, can you hear us? You've got to unmute your... All right, let's try this again.
Can you hear me now?
We can't hear you, counsel, at all.
Can you hear me now?
No, we're not getting anything. Did you try calling in on a phone?
Yeah, I'm on the phone right now.
We can't hear you. Yeah. Mike, if you're listening, can we establish a phone contact with counsel?
I see. Oh, his phone just left the list, Your Honor.
All right, counsel, we're going to hold you off one more time until we can, and call the office, call the court here, and see if you can work this out with IT once again, but right now it's not working. We are going to call case 373. Justice Hannah is recused. 373 is Brown versus City of Buffalo. Do we have, I have 2 counsel arguing here, but I have 3 up here. Who's arguing, who is it?
Your Honor, I'm Kenneth Kaczynski. I checked in on behalf of the defendant attorney.
And counsel, you're just co-counseling this, not arguing?
No, Judge, I represent the plaintiff, Mr. Nick Brown, on this as well.
You're not scheduled to argue, though?
I thought that I was, but apparently...
We don't have you scheduled to argue. Counsel, do we have any objection to counsel arguing this appeal?
I have no objection, Your Honor.
I mean, yes, he didn't put in any papers, he didn't submit any documents. Without an opportunity to rebut what he has to say, once I'm done speaking and I sit down, I have no opportunity and no
Counsel,
indication.
I understand your objection, and counsel, I'm afraid you won't be able to argue today. Very good. Proceed, counsel.
Good morning, Your Honors, and may it please the court. My name is Emily Cobb, and I represent the defendant appellant Mukhtar. This is an appeal of a denial of defendant's summary judgment motion at the trial court level. The instant case arises from a two-car motor vehicle accident in the city of Buffalo. There is no dispute that defendant Mukhtar entered the subject intersection traveling below the speed limit, paying attention to the traffic in front of him, and with the right-of-way.
Well, the paying attention to the traffic in front of him, I mean, I agree with you that we don't have any evidence of any traffic, any cars going his direction. We have this concern, and you raise it in your brief on page 13. Clearly, there was no time to take evasive action. And then we have this testimony that Mr. Kajewski's client relied on, this 30 to 40 seconds, and I saw that on page 105, and then I saw the correction on page 133, 134, and he says, no, wait a minute, it was instantly, and clearly he misunderstood that first question when he says 30 to 40 seconds. Well, I shouldn't say clearly, because maybe Mr. Kajewski will have a comment on that, but let's be okay with the correction. The thing about the correction, though, that just bothered me a little bit, the questioning was, okay, you didn't see it 30 to 40 seconds before the collision occurred. And he says, no, I did not. But that's not all he said. He then said, I did not see anything. And then the question was, I think it was your question, okay, is all you said. And then he says, it was just a big bang I heard. So I read that, and then I think there was like a leading question about, well, wait, you did see it a foot, because that was his prior testimony. He said, oh, yeah, I saw it a foot. But we have that statement in the record that I didn't see it at all. And so you have that, and that's a little troubling. The foot is a little bit troubling, too, when you look at where the damage on the plaintiff's vehicle occurred. It was so far in the back. The police officer, I think, remarked it was like in area 6, had written on the, which is actually, I think Mr. Mukhtar said it was like in the middle of the car, like right where the passenger door, the back door, and the front door are. But the police had it even further back than that. So the vehicle had to come around the building, there's a building there, sidewalk, other lane, the eastbound lane of Walden, past that, then the front of the vehicle has to get in front of Mr. Mukhtar, and then he hits the back side. And even if he says at 30 miles an hour a foot, how do we not have an issue of fact that he's not keeping a proper lookout, that he should have seen it a little earlier than that?
Because there's no expert to indicate that. There's the opposition to our motion. There was no expert that said that had he been looking at exactly the right place at exactly the right time, he should have seen this vehicle. And I do think that his
No one
testimony...
hired me to be the expert.
No one hired me to be one either.
All right.
And Your Honor, I do think that the witness's testimony was rehabilitated at the end of his transcript. Clearly, he did not understand the question when he was asked it the first time, which is why I rehabilitated him at the end, just to clarify that it could not have been 30 to 40 seconds that he saw that vehicle. Also, as Your Honor indicated, his view of traffic in the intersecting street was obstructed because there is a building at that corner. This accident happened at 6 o'clock at night. It was dark out. And also, one thing I want to mention, this is not a motion about who was driving the other vehicle. It's not a motion about what, if any, liability the Buffalo Police Department has relative to this case. The only issue is whether or not there is sufficient evidence that there's a question of fact that defendant Mukhtar was negligent and that should go to the jury.
Right, and no one saw your client's vehicle before the impact.
No.
So all we have is your client's testimony as to his behavior, what he was doing, and that's it.
That's correct. I think his testimony speaks for itself. The law only requires that he act in a reasonably prudent manner as an ordinary motorist would. And there's no indication that he acted in any other fashion on that night. He wasn't impaired. He wasn't distracted. There was nothing out of the ordinary or unreasonable as far as his conduct was concerned.
Well, their burden's even greater than you, because your client was, was following the law. He was following the traffic control devices, and your opponent's wasn't. So he's not required to or he's not required to anticipate somebody's going to be breaking the law, correct?
That is correct. In fact, my client has the right to assume that traffic approaching from the intersecting street will abide by the traffic control device, the stop sign that controlled their lane of traffic. My client's not obligated to slow down at every single intersecting street or have his head on a swivel to look in every direction at all times. He's entitled to presume that the other driver will obey the traffic laws. Unless there's any other questions from the court, I will rest on my papers.
No further questions, counsel. Thank you.
Thank you, Your Honors.
Thank you, Your Honors. Kenneth Krajewski, on behalf of the defendant McCarley, may it please the court. I would be happy to rest on Justice Noack's argument on my client's behalf, but if I could just expand upon that a little bit. What I've heard here this morning is that it's clear that he misunderstood that first question about 30 to 40 seconds. Well, you know, we have a procedure for that, right? If there's an error in the transcript, then you send the transcript to the client, and the client reviews it and puts it in a errata page.
You didn't argue that in your brief, though, did you?
No, we did not. You're correct, but I don't think anybody said clearly that clearly he misunderstood. That was not raised.
But an errata sheet doesn't always solve the problem. If a witness testifies one way in the beginning of the testimony and then is rehabilitated, as counsel argued, later on, the witness is simply clarified or attempted to straighten out the testimony, and maybe an errata sheet wasn't necessary at that point. But the question becomes, which testimony is correct? And which testimony is relied upon, or does that amount to a question of fact?
Well, exactly, Your Honor. That would be my argument, would be if he has been rehabilitated, isn't that an issue for the trier of fact to determine whether or not the erroneous testimony early on has been sufficiently rehabilitated or rebutted or in whatever fashion? That's a decision for the trier of fact. I will say this. I would step across the line a little bit and say I respectfully find that Justice Del Monte in his decision probably used wrong terminology. He talked about credibility, okay? He wasn't really evaluating credibility. He was evaluating inconsistencies. And that's really what we have here. And that I did, Justice Greenwood, raise in our brief, okay, that is, and we did raise that in the court below. Counsel,
what about the argument that you're required to come forward with some facts to indicate the theory that Justice Noack was proposing, that it just can't be Justice Noack saying it, it's got to be in the record that somewhere.
That's where I was going, Your Honor.
Okay, sure.
That's exactly where I was going. So, right, page 105 of the record on appeal, we have his statement. I don't remember exactly. It was somewhere like 30 or 40 seconds, okay? Now, whether we believe that or not, or whether we find that to be a misunderstanding or clearly or not.
Can you read me the question that was asked of him when he answered
Sure.
30 or 40 seconds?
Sure, Your Honors. Page 105 and lines 2 through 6. Okay, now from the time you saw the car coming from Lathrop to the time that the collision occurred, how much time elapsed? I don't remember exactly, but it was somewhere like 30, 40 seconds. Okay? So then we go on. We go on to page 128 of the record, lines 10 through 17. Do you know the speed, comma, about, comma, of the car that hit you? Answer, I don't remember that, comma, but he was coming real fast. Question, was it faster than the speed limit? Answer, yeah, it was really fast. I don't remember exactly their speed, but all I remember hearing a big bang in front of me. Continue on. Page 134 of the record. lines 1 through 16. Question, sure. How much time between?
Counsel, I'm gonna interrupt you, and I hope I'm not interrupting the answer to the question you had.
My question was answered.
Yeah, you don't need to read
Okay.
16 lines of testimony for us. The record's before us. And we'll be
Okay.
happy to take a look at it if you simply refer us to the pages you want us to read.
Okay, page 134, especially lines 10 through 12. The first time you saw the other vehicle was a split second before the two cars collided. Is that your testimony? Answer, yes. Okay.
So your argument is that well, why don't you tell me what your argument is?
I have
What's the
one-
basis for what does this testimony tell us, or should tell us?
His testimony tells us inconsistencies. 30, 40 seconds, oh no, instantaneously. Okay? Oh, I didn't see anything at all, but I saw the other car was speeding, going beyond the speed limit. Okay? The questions for a
Questions of
rigorous,
jury is what you've already told us.
rigorous cross-examination.
These should be subject to cross-examination in front of a finder of fact.
Yes. If I'm questioning him at trial, I'm saying, you don't really know what you saw, do you? Or when you saw it.
May I ask one other question?
Of course.
Just in terms of, this is a preservation question. This notion that I think I raised with Ms. Cobb is this notion that maybe he didn't see it at all. That, oh, he heard a big bang, I didn't see anything, little bits of testimony that I've kind of taken out of context. Did anybody do that below? Is that preserved, or am I making that up? Has anybody suggested, either you, the plaintiff below, I don't know, whoever else did paperwork below, did anybody ever suggest that maybe he didn't see the vehicles at all?
Page 59 of the record, our paragraph 48, we reference that, Your Honor, as cited above, according to police report, et cetera, Mukhtar's testimony reveals he did not slow down as the vehicle approached the intersection where the accident occurred. Mukhtar testified unequivocally that he didn't pay attention to that area of the intersection.
Anything further, counsel?
Nothing further, Your Honor. I think I've made my points.
Thank you, counsel.
I thank the court.
Thank you, counsel. Recalling case 374, hoping third time is a charm. Vermillion versus the Roofing Guys, Inc. Counsel, if you'd unmute yourself there, we might be able to hear you.
Henham, you hear me now, Judge?
Yes, much better. Thank you, counsel. Whatever you did worked. Now, your opponent has submitted, so you want to be heard?
Yes, please, Your Honor. I'll be very, very brief. I do think the trial court got it right here. I don't think that the consequential damages in this case were at all foreseeable, and they weren't contemplated in the contract that my client had with plaintiff. So if there are no questions, I would just wrap up my brief.
Counsel, thank you for your patience with the court. Thank you very much.
Hey.